Good afternoon. All right, we are on the record in the matter of People versus Latavis, Trashad, Thornton. This is case 25-0203FY and may have appearances for the record, please.
George and Ed on behalf of the people, Your Honor.
Thank you. And
I'm Melissa Vachon with the Office of the Public Defender. Your Honor, I would note for the record that I am present and I did speak with Mr. Thornton. However, he is declining my representation at this arraignment.
okay, and Mr. Thornton, could you state your name for the record, please?
I will object to being called Mr. Thornton. I am, for the record, my name is Shoulders. I am here as legal representation for Latavis Trashad Thornton, which is a nonprofit organization.
Your Honor, I'm looking at his file from 2022. I think he was sent to competency back in 2022, and it looks like that's going to be the same issue today. It's my understanding that he might have a bench warrant out for his arrest for sentencing. He pled guilty to, I believe, attempted R&O in November 8th of 2022, but he failed to appear in December 2022. And looking earlier in the files, I believe he was sent to competency as well. And it looks like this is going to be the same issue. So if the court is inclined to send him to competency, I'd ask for that.
Objection again, Your Honor.
Everything comes through me. You're going to get your turn, okay? But I have to run this in sort of an organized fashion, in part for you, because if you want to appeal, you want a transcript that is coherent and readable, okay?
I'm sorry. I don't know. Were you speaking to me or
yes,
to
sir,
Mr. A?
Mr. Thornton. So if you want to appeal,
I just want the record to be correct, and there was no objection. There was no objection to the statement that I made about Mr. Thornton, about Latavis Trashad Thornton being a nonprofit organization, and I was just objecting the points that the attorney prosecutor made.
Okay.
Welcome back to the channel. Today's courtroom encounter features a textbook sovereign citizen meltdown that turns into a legal masterclass by an unshakable judge. Meet Latavis Trashad Thornton, a man who insists he's not Mr. Thornton, but rather a legal representative for a non-profit organization. If that sounds confusing, don't worry. It only gets wilder. The prosecutor's ready, the public defender's ready, and the judge, well, he's about to show exactly why patients should earn a medal.
So I want to make sure that we treat you with as much respect. Here's why we have this hearing. You have, under the Constitution, a Sixth Amendment right to know the charges against you. So we have this hearing for that reason. So I want to make sure that you get all of your rights and know everything that is available to know about this case right now so you can defend yourself. That's the whole purpose today. To give you the information you need so you can defend yourself with or without counsel as you wish, okay? We're going to do 5 things this afternoon. First, I'm going to read the charges against you, including the maximum possible penalties, because you have a right to know them. Second, we're going to talk more about your rights. Then, I'm going to enter a not guilty plea on your behalf. I'll give you the opportunity. No, sir. So just a minute. Okay, so you're going to have the opportunity. You can stand mute or plead not guilty. We'll come to that in a minute, okay? So that's the third thing we're going to do. Then, we're going to talk about dates when you return to court. You're going to get those in writing. Lastly, we're going to talk about bond or bail. Okay. So,
can I please?
Because here's the thing. I don't want to be disrespectful to you.
Right. Absolutely.
I know it feels disrespectful, but here's why. Here's my concern. I don't want you to say anything that could come back to haunt you later. So that's why, and this is true of every arraignment I do, I tell people right at the beginning.
And there it is, the first classic move of the sovereign citizen playbook, rejecting the legal name. This tactic comes from the bizarre belief that your legal name is a separate corporate entity owned by the government. They think by refusing that label, they somehow free themselves from legal jurisdiction. The judge, though, doesn't bite. He's polite, calm, and laser focused on keeping order, which is key because sovereign defendants thrive on chaos. Notice how the judge prioritizes the record and transcript. That's not just procedure, it's protection.
I am aware that I am innocent until proven guilty, and that something I say could, like you said, come back and haunt me. I'm well aware of that for the Taylor Church Thornton. However, I do still need to express correctly, and if I'm capable of settling this matter now, why can't we do that? I have more than just the Sixth Amendment right. I have a plethora of rights that are granted to me from God, the Human Declaration, from the Constitution, and so forth. There's a plethora of rights that have been granted onto me. So I don't just want to rely on the few far in between. I would like to rely on all my rights and abilities, and if possible, take care of all these matters in the most dignified and respectful way to keep the court's dignity and my dignity as a man. And furthermore, as a preservation of my innocence, I would like, until proven guilty, I believe that is pertinent that the innocent factor be imminent here.
Absolutely. So here's what I'm going to tell you. And I tell this to everyone at this stage. The most important thing I can tell you this afternoon is that you are innocent. You are innocent unless you remain innocent unless at some point you plead guilty or are found guilty beyond a reasonable doubt at trial. And I say unless for a reason, because it's different than until. Until means something's going to happen sooner or later, right? We'll be here until Saturday. Saturday is going to happen. Unless means we don't know what's going to happen. And in your case, we don't know what's going to happen. You haven't seen the evidence. Okay, I'm going to keep going through this, and then I'll acknowledge you in just a minute. You haven't seen the evidence.
Okay.
No attorney has seen the evidence. The court hasn't seen the evidence. So you remain innocent unless you plead guilty or are found guilty beyond a reasonable doubt at trial. And now I'm going to read the charges against you because you have a right to know them. Okay, you can't really defend yourself unless you know what you're accused of. Maybe you remember being a little kid and going to the principal's office and not knowing what you might be in trouble for. No? Okay. Well, you were probably a better little kid than I was. But I'm going to read the charges against you. It's going to take some time reading all the way through them.
Before you get to reading, can I make one statement, please?
Well,
Your Honor?
You can, but let me read through these first, okay? Let me read through these first because I want to make sure I cover everything. The other thing is judges use scripts. And the reason we use scripts is to make sure everyone gets all of the information and to make sure we treat everyone the same.
I'm aware of that, Your Honor. And that is why I feel it necessary for me to make certain things known for the Taylor Church Thornton, for that the script so we can stay in honor. Once again, I have no intentions on dishonoring the courts. I'm even here to surrender all of the interests of the Taylor Church.
He's trying to educate and control simultaneously. By calmly explaining why objections don't exist at arraignment, he's not just addressing Thornton. He's narrating for the record, ensuring every procedural detail is justified. This is expert courtroom management. Neutral tone, complete clarity, zero emotion. For anyone watching who's ever wondered why judges don't argue back, this is why. Arguing risks bias. Explaining keeps the power where it belongs, with the law.
Taylor Church Thornton is really a nonprofit organization, and I am not a surety for it. And it is a company, and it does not profit. So with that information, I understand that the script goes a little different, and I understand that I have the right to let it be known that I'm not the surety, and nobody has. I'm sorry, and
okay, all right.
Yes,
so
ma'am.
here's
Your Honor.
Here's the thing. That's okay. That's not an issue. So here's the thing. I don't know if you remember when a guy named Mitt Romney was running for president some time ago, and he said, and he really upset people with this. He said, corporations are people, my friend. And a lot of people made fun of him, but corporations are people. So that LLC would be a person in the eyes of the law, but a person does not become an LLC. But regardless, I'm going to read these charges because you have a right to know them. So in count 1, you are accused of police officer assaulting, resisting, and obstructing, contrary to Michigan law MCL 750.81D1. This is a felony punishable by up to 2 years in prison and or $2,000 in fines. In count 2, you are accused of assaulting, resisting, or obstructing a police officer. This is, again, a felony punishable by up to 2 years in prison and or $2,000 in fines. Lastly, in count 3, you are accused of, again, assaulting, resisting, or obstructing a police officer. This is, again, a felony punishable by up to 2 years in prison and or $2,000 in fines. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D6 for another violation arising from the same transaction. And this is alleged against the peace and dignity of the people of the state of Michigan. Now we're going to talk about your rights. You have the right to an attorney, and today Attorney Vachon is standing by. If you can't afford an attorney, the court will provide one for you, and we have superb public defenders in this court. That said, you can hire any attorney you wish. You would have to pay them, but you could choose whomever you wish. Now, there is an option for you to represent yourself, and we'll talk about that more at a future court hearing, okay? You have the right, as this case goes forward, to have these charges heard at a trial. And at that trial, the prosecutor would have to bring evidence against you. You could question that evidence, and you could question any witnesses the prosecutor called. You could call your own witnesses. And if they didn't want to appear, the court could issue a subpoena, and the court could make them appear. At a trial, you could testify on your own behalf, or you could remain silent. And if you remain silent, no one could use that silence against you. At a trial, you could bring any evidence you wished, or you could just sit there, because it's the prosecutor's job to prove guilt beyond a reason.
Thornton invokes God-given rights, human declarations, and plethora of rights, which sounds powerful until you remember the courtroom only recognizes constitutional law. Judges don't interpret spiritual rights. They interpret statutes. But the judge here handles it masterfully. Instead of mocking or escalating, he folds the lecture into a civics lesson, calmly outlining due process, presumption of innocence, and what unless truly means an innocent unless proven guilty.
A plea would have you pleading, would have you pleading guilty to all those charges. We've got some back and forth here. It kind of sounds like we're underwater. So a plea would have you pleading guilty to those crimes, 3 felonies, without having seen the evidence against you. So you can stand mute and the court enters a not guilty plea, or you can say you want to plead not guilty and you would be not guilty. Then what happens next, and here's why, then you have a chance to get the evidence against you and to consider it. And I think that's what you want to do, because that is your hard-fought constitutional right, among other things.
It's a bit more to it, Your Honor. That's the issue. So based off of the things that you stated, that's not what my understanding is. From my understanding is I was attacked by some people and I was protecting
Sir,
my life.
I know you don't want my representation, but I would advise.
No, ma'am.
I would
Please
advise
don't.
that you not
Please
talk
don't.
about anything that happened.
Please don't, ma'am. I appreciate that. I'm aware of why you're doing that, but I'm aware. Like I said, me and the judge, I told her something that I might say could come back to haunt me. I'm already aware of that. So thank you so much, Miss Melissa, but please do not intervene. But once again, back to you, Your Honor. From my understanding, I was assaulted, and I am shoulders. Once again, I have never told anyone. I don't want you to mute me, Judge. This is going back to this situation. Okay, thank you. I never told anyone that I am Latavius Trayshawn Thornton. Not one time. I have reiterated. I am Shoulders Latavius Trayshawn, not just to you, Your Honor. That's so to be redundant for the record. Okay. I have reiterated that Latavius Trayshawn Thornton is a nonprofit organization. I am not a surety. I am Shoulders. I am appointed to be an administrator for Latavius Trayshawn Thornton. No, that's why I'm here, but not a surety for Latavius Trayshawn Thornton. Furthermore, Your Honor, my understanding is I was attacked and assaulted, and I'm not sure if I could let that be known to you so that we can make that case come about, because I would like to seek forward that using the evidence from all the evidence that they have gathered. I would like to use it in my.
Did anyone else catch the irony? Thornton passionately insists he wants to respect the court's dignity while repeatedly interrupting it. And that's a sovereign paradox. They demand recognition while rejecting authority. Quick poll for the audience. If you were the judge here, how long would your patience last? 10 minutes? 5? Or about 15 seconds? Drop your answer in the comments, because this judge's patience deserves an award.
Still available to you. Right now, I'm going to enter a not guilty plea so you can get the evidence to proceed. All right. Now, next up, we have some dates when you're going to return to court. And let me just pull those up here. Okay, okay, go ahead.
Yes, I just wanted to speak on my previous court history and let you know why it may look the way it looks.
Okay, no, here's the thing. I'm going to ask you to not say anything because I don't want to accidentally become biased.
Gotcha.
So, all right, so here are the dates. All right, you're going to come back for a probable cause conference at 8:30 a.m. March 21st. Now you're going to get this in writing, okay? 8:30, March 21st, and a preliminary exam. You're going to get this in writing too at 9 a.m. March 27th. Now, my best advice would be to speak with Attorney Vachon because she can explain how you pursue those things. Now, we're going to move on for a moment to bond.
Kind of broke up at the end. I didn't hear what you said. I'm sorry.
Okay, we're going to move on to bond or bail. So would you like to be released on bond or bail?
Could you explain the difference to me, please?
Your Honor, I was going to ask for a bond. People
Okay.
have.
We're going to let Mr. Anid go first. All right, Mr. Anid.
The people are looking at MCL 765.6. Some of the factors to
Now
consider.
you're cutting out. I'm sorry. Go ahead.
Okay, if he says something like that, would it make you biased? Couldn't you be speaking to make you biased?
Well, I'm going to come back to you in just a minute, okay?
Okay, no problem.
All right, Mr. Nid, I'm sorry you were cutting out, but please.
Your Honor, the people are looking at some of the factors to consider bond. The people are asking for at least a $25,000 cash surety and GPS tether if he does post bond. We're looking at the seriousness of the offense charge, the protection of the public, the previous criminal record, and the dangers of the person accused, the probability or improbability of the person accused appearing at trial of the cause. All those factors are not in favor of the defendant, Your Honor. He failed to appear for sentencing in, I believe, circuit court. And again, Your Honor, if the court has updated lien, if you can see if he has a warrant from a couple years back, that's for pleading for attempted resisting and obstructing, is what my note indicates. Protection of the public, Your Honor. This case involves assault on officers. I think one officer got punched in the face. The previous criminal record, he has 4 criminal histories from 4 different states, Your Honor, pending from.
Okay, no, he's going to get, and then I'll hear from you, okay?
And his probability. Your Honor, lastly, he failed to appear for several years on sentencing. He's not going to appear for this case if he gets released. I just asked for a high bond and a GPS tether if he posts that bond. There's a lot of risk to the public in this case, and he obviously he has ties to Indiana, Kentucky, Georgia.
They twist a single line of corporate law into a full-blown identity crisis. Here, Thornton insists that his nonprofit organization is on trial, not him, as if you can swap yourself out for an LLC. The judge even references Mitt Romney's infamous corporations are people, quote, not as mockery, but as a perfect legal reality check. Because yes, corporations are treated as persons in certain contexts, but people are not corporations.
Yes, Judge.
Okay, so I'm going to start with Mr. Nid has spoken. I'm going to start with Attorney Vachon. Attorney Vachon, anything from the breakout room?
No, Your Honor, the defendant will speak for himself.
Whoa.
Okay, sir, please proceed.
Okay, Your Honor, thank you. Mr. Thornton is not a flight risk for, he has multiple properties in the Michigan and the Lansing area that keeps him here. Also, he has a lot of things he do here. He's a coach for fourth grade, fifth grade, sixth grade basketball teams, and they play year round. He's also a mentor to young children and to people who have had traumatic situations. They call on a daily. He's a counselor to the community and to the public. Furthermore, he's not a danger to the community or based off of his innocence, and he's not a threat to anyone in the society. He is actually beneficial to Mr. Thornton is actually a beneficial role in the community, and kids and multiple different areas of people, they look up to Mr. Thornton and they will attest to his character as an upstanding, nonviolent, peaceful individual who brings smiles and love to the community.
3 felony counts, each carrying potential prison time. And our defendant still thinks this is a debate club. What's striking is how the judge keeps grounding the conversation in rights and reality. He gives Thornton every chance to understand. This isn't philosophical, it's criminal. You can't reason your way out of charges. You can only legally defend against them. And Thornton, he's still stuck in the wrong courtroom universe.
Okay, so I am looking at the file and I want you to bear with me a bit. There was a song when I was younger. When I was in high school, there was a popular song that said, "Cruel to be kind." Okay. So I'm looking at this, Mr. Thornton, and there's a warrant out of 30th Circuit Court, downtown, East Lansing. Okay.
Yes.
And this is from 2022. And it's a statewide pickup, no bond with extradition. So here's what I'm going to do. I'm going to come back to that in just a minute. I'm going to set a money bond of $10,000 because all of the days that you don't post that bond, you will get credit for the time. If I gave you a cash bond, what would happen is Ingham County would pick you up on this old warrant and hold you until that case was resolved. By setting a cash bond on this, you get credit for the days you're in. Then, when that's resolved or close to being...
And that's the end of this particular sovereign standoff. The judge enters a not guilty plea, protecting the defendant's rights despite his confusion. Whether you're a sovereign citizen, a public defender, or a YouTube lawyer, the courtroom runs on procedure, not personality. The judge handled it with patience, precision, and professionalism, turning chaos into order one explanation at a time.